And yeah, like I was saying earlier, where's questions 1 and 2 were very straightforward. And this one here I thought was straightforward as well, except it had an issue that most people weren't used to. And I know it's the shelter rule. And we're gonna get into that. And then I've been giving out opinions here on how the bar examiners are thinking. Of course, that's just my opinion, but we'll get into it in a bit. Okay, so let's go ahead and show the okay, so I produced this just for this session here, you guys. I did a little walkthrough of the issues here because there was a lot of facts, there was a lot of issues. And again, I thought it was straightforward, except for that shelter rule question. I think that question threw a lot of people off. Okay, it says number one. By the way, thank you so much for joining us. Did Carlos take title to the house subject to lender's mortgage? Uh-oh. All right, it's now we're talking about a mortgage. Now we're talking about maybe modified. We're talking about the BFP concept, bona fide purchaser for value. Maybe that'll trigger the recording statutes. So you see what's happening here? Okay, so let's just go ahead and read this. I actually enjoyed this question. It says Allison bought a house and the lot on which it sits with the proceeds of a mortgage loan made by the lender, new lending. Allison intended to repay the loan when she resold the house. And it says to improve ventilation in the kitchen, Allison installed an AC, and then it was screwed and bracketed, all that good stuff, the exterior wall. Okay. Then it says here, impressed with Allison's improvements, Barry, the buyer, offered to buy the house at the market price before Allison listed it for sale. Okay. So he's making an offer. Allison and Barry agreed on the terms and quickly finalized the sale of the house. Okay, great. So it does say there market price. So he gave valuable consideration. Okay, due to his haste, however, the lender did not record its mortgage until after Barry had recorded that deed. Okay, so now we have to think, did Barry have any type of notice of that mortgage? As a result, the lender's mortgage was not satisfied from the proceeds of the sale as planned. So here's what I wrote here. Okay, did Carlos take title to the house subject to the lender's mortgage? And I wrote here, Addison purchased the house. Okay, subject to the mortgage issued by the lender. Okay, we get that. Lender did not record the mortgage until after the sale took place. Addison sold the house to Barry. Barry recorded his deed. So Barry is going to be a BFP. All right. And then of course you have to look at the options at the notice, at the type of notices. You have what do you have? The constructive notice. You have actual notice, you have inquiry notice, and that doesn't seem to be present there. So I just said, hey, look, Barry's the BFP. Okay, I think most of you guys would agree with that conclusion as well. Then it says here, okay, so we're good right there, right? We're good. Everything so far so good. So far so good. Then it says, what claims is BFP protected from? Okay, a BFP is, I think you guys know this. It's a legitimate buyer who is not aware of a prior claim or issues affecting the property. They are free from prior claims. All right, so that's huge. That's fantastic. And would this include a mortgage? Yes. Thus, Barry would not be personally liable for the mortgage. Okay, great. I think most of you guys concluded that. Okay, so then after that sale between Allison and Barry, then the lender records the mortgage. So now the world has they have actual notice. Okay. Well, actually, they have constructive notice. Okay. They don't have actual notice because the facts tell us that there was no actual notice. Okay, great. Now, what happens after that? What happens? That's where it gets a little complicated there. Okay. So then after this, Barry sells the house to Carlos. It says here, soon thereafter, we're good. Everyone's good up to this point, right? Soon thereafter, Barry was able to sell the house at a profit to Carlos. Okay, so Carlos does pay valuable consideration. Barry and Carlos did not actually know of lender's mortgage. Okay, so there was no actual knowledge, actual notice there. Okay, but remember, it was recorded, so then they had constructive notice. Okay, when the sale of the house was finalized, although the mortgage had been recorded weeks earlier, constructive notice. Barry gave Carlos a general warranty deed. All right, so let's talk about that. And that's where, okay, so I think we can all agree that Carlos was not a BFP. Why? Because he he had constructive notice. Okay, if he has some type of notice, he doesn't qualify as a BFP, so he can be liable for that mortgage unless there's some kind of crazy rule out there. And that's what's happening here. We have the shelter rule. Let's go ahead and read this. One who takes from a BFP. So did Carlos take from a BFP as we discussed? The answer is yes. So that element is met. Okay, the transferee. So what's the effect there? The transferee takes shelter in the status of the transferor. Okay, great. And thereby they step into the shoes of the BFP. So Carlos is going to step into the shoes of Allison for that shelter. Okay. So then we conclude that Carlos is also a BFP based on the shelter rule because he stepped into the shoes of Barry. Okay. And Carlos would not be personally liable for the mortgage. Now, many of you guys, I already know. I somehow I already know. Okay. A lot of you guys did not discuss the shelter rule. Now, let me tell you what's going to happen here. For those few people that did discuss, well, not a few, but more than a few, a small percentage, what's going to happen most likely is that you're going to be given extra credit for that. You're going to be given like maybe 5 extra points, 10 extra points, maybe even 15 if you did a great analysis. All right. So if you did not discuss it, can you still get a 65? The answer is yes, because of the instructions. What do the instructions say for these 1-hour essays? They say they want you to analyze the facts and apply it to the law. So in other words, do an analysis. Okay, so a lot of people think that these 1-hour essays are testing you on your knowledge of the law, which they are, but also they're testing you on how well you analyze. Do you see that? So if you did not discuss a shelter rule, but you did a great analysis somewhere that you remember, I think you're going to be okay. It's not where, okay, you didn't get this issue. Okay, automatic -5 points. And how do I know this? Because I've just studied the bar exam a lot for years. And okay, that's what usually happens. And I took the exam several times too. And sometimes I would see like, okay, I didn't do a good analysis, but I got this issue there. I was like, yeah, look, they gave me a great score. Okay, so from personal experience, I already know what's going to happen there. Okay, but it's a little tricky. I get it. So if you discuss the shelter rule, okay, props to you. Well earned. But if you didn't, again, it's not the end of the world. Okay. Now, okay, so I think that takes care of question number 1. Did Carlos take title to the house subject to the mortgage lender? The answer is no. Now, let's go ahead and go to the other issues here. And I know that by the time you get to this question 2, you're kind of, if you didn't get the shelter, you're thinking, man, I'm not sure about this. You get rattled. The bar examiners, they're great at building that tension. Okay, but that's why I say just keep your composure, discuss you do your counter argument, all that good stuff. Okay, what claims, if any, does Carlos have against Barry under the general warranty deed? Okay, so let me see if I wrote something. It says here, I haven't looked at this in a while, earlier in the week. And so much happens between now and then. Okay, in the legal world, it's like, okay. It says here, okay, so we have a general warranty deed. By the way, just see if you guys are going to do some type of family law or something that deals with transferring deeds, you never want to do a general warranty deed. Do a quitclaim deed. Okay. So let's see what we have here. Guarantees. Okay, so we have here some present covenants and general covenants. I just wrote here that there's one warranty here, it says here that that's going to actually apply. And it's going to be the one, let's see now, not liable. Okay. So the right against encumbrance guarantees that the grantor has disclosed to the grantee any and all of the subjects of the property's encumbrances. That would include a mortgage. So that's the one you would focus on. Okay, so let me see what I have here. Okay, yeah, so here we have in the fact pattern that he's not disclosing that there's a mortgage there. He did not disclose that to Carlos. Okay, so then what do you have? What type of claims can Carlos make? And of course, he could say, hey, look, there's a breach of contract. He could, as far as remedies, he could maybe do a rescission. I don't know, maybe they settle out of court. So this is not really a remedies question. They just want you to say, hey, look, because what is the claim that he can make? Okay, so yeah, so was there a breach again? Was there a breach of the general warranty deed? Yes, there was a breach. And I just discussed it. It was this breach, the covenant against encumbrances, because these are promises. These are promises that the seller is making to the buyer. Hey, look, I'm gonna make this promise. I'm gonna sign it. That's what I'm saying, you guys. In actual practice, stay away from the general warranty deeds. Okay. Now, so far so good, right? Considering everything else. Okay, let's go on to question 3. Is Barry liable to Carlos for the value of the AC unit? Okay, so then they're asking you about fixtures. A fixture considered part of the real estate sale. So then you have to determine whether that AC was that a fixture. Here they give you a lot of clues. It says here, Allison installed an air conditioning unit screwed to a bracket mounted through an exterior wall. So that sounds to me like it's a fixture as opposed to personal property. If it's personal property, like a microwave or whatever, take it with you. It's not part of the sale. Okay, so that's that. That's question number 3. All right. So any questions on question 3? Okay, so let me see now. Is that rescission or not rescission? It could be a rescission. Yeah, so Carlos could say, hey, look, I rescind. I want to rescind because there's a breach there. So yeah, if you threw that in, fantastic. Again, they're not asking you to analyze it. You're just saying, hey, look, what claims can they make? Again, this is not a remedies question. You would run out of time. So a lot of times when you engage a question, you have to consider that. How much time do I have to answer? That I already discussed the major rules there, the major issues. Okay, great. All right, let's go on to, let me do this. That was 3. Question number 4 for my assistants. Okay, so far so good. So far so good, right? Overall, we're doing great. Everyone's doing great. Okay. So let's see now. Okay, so what is this one? Again, the reason why I have 2 of these because I have my notes on one side, on one end. Okay, give me a second. Sometimes you guys can't see my screen. Okay, so I have another question for question 3. So let me go back to this. And what should I do with this? Let me go ahead and just close this. Okay, I'm gonna make this a little bigger. Okay, so the question there says, what type of rescission and should be a rescission? Okay, so again, that goes more towards a remedies question, right? When you rescind a contract, then it's just like if the contract never existed. So in this case, would Carlos want to do that? Would he want to rescind the contract? I mean, this is probably a little bit more of a discussion than it's probably a little bit outside of the scope. But I think it would be a good idea if Carlos were to rescind the deed. Why? Because you have a deed and you have a title there, an instrument that's directly tied to the title. So it's a security. It's a secure transaction. What does that mean? It means that if that mortgage is not paid, that house is it's going back to the lender. You see, so maybe in the real world, Carlos want to say, I don't want that. All right, because then I have to keep my property, I got to pay the lender. What if Allison, what if she's MIA? Okay, so it says here, just letting you know that there is a typo, should be rescission. Oh, okay, yeah. Oh, my type. Okay, yeah. Okay, with an E. Okay. Okay, recession. Okay, recession. Oh, okay, so yeah, so I think I made a mistake with recession versus recession. All right. Yeah, a lot of times you guys like, for me to create this, I do it like early in the morning, so I won't go to the gym early in the morning, so yeah. Okay, but thank you for that. I appreciate that.